The convicted Walter Sisulu University student Sibongile Mani plans to appeal both her conviction and sentence. This after she was sentenced to 5 years direct imprisonment for the theft of 14 million rands erroneously paid by the National Financial Aid Scheme to her account. Now, according to the National Prosecuting Authority, the appeal hearing has been set for the 11th of April next month, and they intend to oppose the appeal. The 31-year-old spent over 800,000 rands on luxury items before she was caught. Mani's lawyer pleaded for a suspended sentence given overcrowding in prisons and that she was a first-time offender. But East London Magistrate Twanette Olivier handed her a custodial term. The student was only entitled to a 1,400 rand food allowance at the time of the incident. All right, staying with that story, I'm joined now by legal expert Nthabiseng Dubazana. Nthabiseng, good evening. Good to have you with us tonight on In Focus. Is direct imprisonment the only form of appropriate sentencing here? I mean, a technical glitch clearly happened in 2017 that led to this company erroneously depositing money into her account. Of course, she then spent the money on luxuries and other things. Are there no considerations here at all?
Well, the magistrate had before her 2 reports. So usually when such a matter is heard before the court, what we do as defense attorneys is try and find as much mitigating situations to prevent our clients going to direct imprisonment. So a correctional services report was done, and also a social services report was done. Both reports suggest or recommend to the magistrate that a custodial sentence is not suitable for the accused. They suggest that correctional supervision should be the one that should be considered for the accused. And the magistrate decided to go against those recommendations and decided to award the accused direct imprisonment. So to answer your question, there was more than one alternative to sentence the accused versus direct imprisonment. Yeah. But the magistrate chose to not go that way. Of course, they have leeway to do so. However, at the end of the day, we must remember that magistrates are bound by higher courts, of course, and their decisions, and also their creatures of statute. Now, having looked at that, I think that the magistrate did not apply her mind thoroughly for Section 276(1)H, which basically stipulates the kinds of different forms of sentencing that is available to her. And based on the mitigating factors that were offered to her, she chose to ignore that. In fact, if I'm not mistaken, the wording she used in her sentencing today was that the state is being tasked to deal with white-collar crimes, and which, in my opinion, of course, this matter that we're dealing with today does not fall under the umbrella of white-collar crime. She used a sanction so harsh for a crime that doesn't fit that is happening, what happened in this matter today.
Why do you think the magistrate was hesitant to apply some level of leniency here?
I actually don't know. I am actually gobsmacked. Remember, my job at the end of the day is to mitigate and fight for my client as best as I can. So such a circumstance for me does not make sense. I don't understand how she got to that conviction. But anyway, maybe the factors that we are not privy to, for example, what was argued in the heads of argument for both the state and the defense, perhaps the cases that were used in order to bring forth or bring light to the evidence that was dealt with during the trial were not convincing enough, because when I listened to the sentence that she did today, she made reference to cases stemming from 2004, another one from 2014. These cases are very old. We have recent cases where people have been found guilty of monies that are higher than 800,000, and they were still granted suspended sentence or non-custodial sentences at the end of the day. Why would it be that in this situation that it would not be the same application? But then again, I'm not privy to what was argued. I'm not sure what was given to her that made her decide in the alternative.
Yeah. Well, the defense team saying they will be appealing this, more than likely meaning that they will still be appearing before the same magistrates for this particular appeal. Any possibility and likelihood of success that at least you will listen to the mitigating circumstances this time around?
Let's hope that she will. However, I'm not sure, because I heard you earlier that the legal team is intending to appeal both the conviction and sentence. I think on the conviction they might fail. Perhaps on the sentence you might grant leave to appeal, and perhaps a higher court might look at it differently. But I'm not sure that there's a high chance of success on the conviction itself because of the definition of theft itself. She did appropriate the money. She did spend it at the end of the day, knowing that it is not hers and all of those things. However, the sentence, I still feel that it could have been dealt with differently. They might be successful on that part.
Yeah. The NPA is still to ventilate, I suppose, why they would want to oppose the appeal in this particular argument, because I suppose they feel the fact that she actually did spend this money in a way, going on this spending spree and splurging on things like blankets and so on and so forth, and alcohol and jackets and handbags. She is a full-on criminal. I mean, are there degrees to this thing? And I know, if you're looking at a crime of this nature, for example, if money was to be deposited in your bank account, the banks would show no mercy. But it's mitigating circumstances. A poor kid. I think some students are arguing that come from a poor family. She came onto this windfall. What else would she have done?
Yeah. You know what? When you look at the highlights that the magistrate looked at today when she was handing down the sentence, when she looked at the mitigating factors and all of that, she chose to push aside. She said it's irrelevant, actually, the fact that the money was returned to NSFAS, albeit it wasn't by virtue of the accused, but the money was returned to NSFAS. She said as a result of this company that did return the money to NSFAS, they incurred financial loss, etc., etc. But she forgot that those companies are not the complainants. NSFAS is the main complainant in this matter. And if they didn't suffer financial loss and they were actually put back in the position that they were in before, it should have acted as a mitigating factor, at least in my opinion. So therefore, there are various things that she listed today that I believe were strong in mitigation for the accused not to be granted a custodial sentence. However, according to her, it was not sufficient for her to diverge from custodial sentence.
Now, the NPA arguing that she did not bring the court into her confidence because she declined to testify during trial, choosing to exercise her right to remain silent. Could these be factors that could have worked against her?
Yes, there's numerous case law that state that, the accused has a right to remain silent. They have the choice to not testify if they want to. But case law also stipulates that you must be wary of the fact that if you're not going to put forth your version of events, the likelihood of the matter going in your favor is slim to none. So the fact that she made the choice not to testify could have worked detrimentally against her. I'm not quite sure exactly of the evidence that the state put forth and the cross-examination thereof from the defense side, if it penetrated it in any manner, if the prima facie case was established as a result, and therefore the accused could be convicted as a result. But failure of her to at least, at best, if she wasn't going to testify, do 220 admissions, something, to help her cause. But, it is what it is.
What does it take to prove that it was premeditated? Because I think they say, looking at the shopping spree, she spent money in different towns, and they're saying this was proof that she had planned the theft. And it's difficult. It's difficult for many to comprehend how she would have planned the theft. It's not like she woke up one day and thought, I'm going to defraud the NSFAS of 14 million rands.
Yeah, no, I think the state was taking it a little bit too far there, to be honest. Premeditated theft, no, I don't see how we could get there. What can be argued is that upon the money being deposited into her account, even if she left it for 24 hours prior to her spending it, the fact that she started to spend it, even when the money gets deposited into your account, the reference would show where it comes from. So she is aware that she applied for a student loan with NSFAS. She's aware that she's entitled to X amount of money, but then there was more than what she had applied for. So therefore, spending not only the amount in excess of the amount that was due to her, therefore the intention to steal, that's where it would have started. It cannot be premeditated that she intended to steal money from NSFAS from the moment that, she decided to wake up on that day. It can be from the moment that she started spending that money, that she had the intention to deprive NSFAS with their control or their possession of the money, which falls within the elements of theft, and therefore as a result she can be convicted of theft. I'm not sure if premeditation would really fall within that ambit.
Yeah. A suspended sentence would, I suppose, have a similar impact on her, whether it's custodial or not, in as far as record of her having committed this crime and being convicted of it, and certainly would have implications on her future.
100%. From now on, her SAP 69 records will always reflect the conviction of theft. She will have, I think, about 10 years after that, then she can expunge it, etc. But from now, she does have a previous conviction. That's why I feel that the legal team should not make the choice to appeal the conviction, because I don't see how they're going to wiggle their client out of the ambit or the umbrella of having been found guilty for theft.